Hey guys, what is up? It's Dusty here, and welcome back to another crypto video. Guys, I was already laying in bed, alright? But I stood right back up and went right back in recording because apparently I forgot to cover this lawsuit document yesterday. And you know, I'm Dusty BC. On this channel, we don't miss any single thing, alright? It's been about 24 hours since this news came out. We're a little bit on the late side, but better late than never, right? And make sure you guys press that like button. I was laying in bed, about to fall asleep, before just quickly checking Twitter, noticing I missed something, snap right back into the freaking recording session. Dusty BC don't miss, all right? So this lawsuit document was rather important because it's basically Ripple reiterating all the points they made earlier about how they just need to see what the SEC's thought process was internally about trading XRP. They want to know right now as we currently speak, did any SEC members trade XRP, yes or no? If so, when? And did things change? And all that stuff. They just want to know. It's a really, really obvious and logical request. Now, there isn't anything new though, which is always the case. Whenever it's a reply like this in further support, how that works is we first have Ripple's motion to compel. Right? They basically compelled the SEC to produce documents showing whether the SEC employees were permitted to trade XRP and other digital assets. We get an SEC response, which is them looking at all those points saying, no, we don't agree on these reasons. We get then a Ripple reply to that response, and then potentially we can get an SEC reply to that again. I'm also using some hand gestures, which you cannot see. However, the point is clear. Ripple does not care with whatever the SEC is throwing at them. They just keep throwing some stuff like, well, whatever you're saying, cool and all, but you're wrong. There's no Privacy Act obstacle to the court ordering production of this info. Second, the SEC's opposition letter makes no attempt to substantiate their passing claim of burden of production. Third, the SEC's familiar claim that the materials are irrelevant because only its public external statements can possibly bear on the merits of its claims, mischaracterizes the defendant's defenses, and has already been considered and rejected by the court. So, it doesn't really make a lot of sense, is what Ripple's saying. Ripple once more just says, give us all this information over, and in the short version of it, individual defendants, wait, let's actually read this full part here. Because I am kind of messing up here. Evidence that the SEC permitted XRP purchases and sales by its own employees without any restriction until January 2018, and likely through pre-clearances from January 2018 through at least March 2019, which the SEC refuses to confirm, directly undermines the SEC's claims that since 2013, individual defendants acted recklessly with respect to XRP sales because it was so obvious that XRP was a security, such that they must have been aware of it. Ripple had fair notice that selling XRP was a Section 5 violation, and XRP was an investment contract under Howey. Equally unavailing is the SEC's argument that since preclearance is an ethics office process, it has no possible relevance, even accepting that the SEC's Office of Ethics Counsel, OEC, does not endorse or sanction particular assets when making preclearance determinations. The OEC is responsible for deciding whether to prohibit employee trades in securities and digital assets, which presumably must be based on some assessment of the advisability of SEC staff trading in digital assets and blank. There is an obvious tension between the SEC's broad theory in this case that every offer, sale, and distribution of XRP, end quote, by defendants in 2013 constituted an investment contract, and that the individual defendants recklessly disregarded the law. And the fact, which we seek to confirm, that the SEC's own employees were permitted to trade XRP as late as March 9th of 2019 and possibly thereafter, the SEC will be free to argue how much probative value a fact finder should accord to the trading preclearance evidence. But a fact finder, by the way, being, for example, the judge. But under the low bar for relevance established by the federal rule of evidence and already recognized by this court as having been met in connection with the SEC's trading policies, defendants are entitled to this info in discovery. Accordingly, the court should grant the relief sought by this motion and order the SEC to produce the information defendants seek in aggregated form or anonymized form. We don't really care. We just want that info. And obviously, guys, I really firmly agree with Ripple on the notion that they should get this info. It's extremely relevant whether or not SEC employees were allowed to trade it. And that's ultimately also why they do not want to hand it over, guys. They're trying their best to not give it over. But ultimately, I don't think they'll suffice. I don't think they'll win. I think the judge is going to just throw the hammer onto Ripple's side and just kind of let him slam dunk this one. Because obviously, you cannot tell me that it's not relevant. And all these points that Ripple makes are just obvious ones. Now, unfortunately, Ripple didn't go too far into the William Hinman point right now, which I guess is kind of sad. Then again, it doesn't matter because, of course, they replied to whatever the SEC first responded. But the William Hinman point that they made was also rather interesting, which was, did any trading policies internally change after William Hinman made his speech, specifically about Bitcoin and Ether? But the most, I guess, key part here is that even though this entire notion talks about Bitcoin and Ether, that's not really what they're asking for too much here. They're asking for it, but that's not in their arguments. They're basically arguing purely on the XRP forefront, why it's relevant and why it's necessary. And the Bitcoin and Ether things are just additional. Yet again, very, very relevant though. Now, let's just quickly go through this Twitter feed here as, again, I want to make sure I've never missed anything here, all right? So, some of the stuff that happened yesterday as well was here. We had attorney Joy Guo. Oh, sorry, guys, no, wrong one. Ripple filed its response to the SEC's motion to compel turnover of video and audio recordings of Ripple staff meetings. We already covered this one. It's basically the SEC saying to Ripple, hey, we want your video and audio. Ripple saying, well, we were already planning to give you our video and audio, so why file this motion? That's basically what it was. Then here we had Ripple file's motion to seal certain exhibits and transcript excerpts filed by the parties in connection with the SEC's motion to compel production of video and audio recordings of staff meetings, which is basically why I most likely missed this one. I guess now I understand, right? Because I covered this in a video. I'm going to retweet it as well for some of the guys that missed it out. I covered this in a video. I covered this in a video. And the middle just skipped by, unfortunately. So I'm sorry about that one. But this one is basically a motion to seal. They just wanted to hide some information out there. Then the SEC will stop at nothing to control the entire crypto space. This isn't just about Ripple. Coinbase accuses the SEC of using intimidation tactics behind closed doors to stop the company from launching a lending program. Now, funny enough about that one, I actually have a quote over on my Twitter because Brad Garlinghouse actually quoted this. Is quoted. I read this in Brad Garlinghouse's speech in December 2020. Ripple, Chris, and I may be the ones named in this filing, but this is an assault on crypto at large. In this case, XRP is a proxy for every other altcoin in the space. From there, you have a snowball effect. This isn't good news for any market maker. Exchanges like Coinbase, etc. is what they said. But the etc. had to cut off. It's a literal quote from Brad Garlinghouse in 2020. It's kind of funny how the SEC came in towards Coinbase, rather quickly afterwards. At least I find it funny. Then SEC v. Ripple. Here's a good letter from someone at the SEC, or someone the SEC says it protects. It's worth reading. So this is a letter, an open letter to Judge Torres and Ned Byrne from just a community member. Let's read through it really quickly here. All right. So dear judges, my name is Brian, and I'm a middle-aged working U.S. citizen who has dreams of better things to come for me and my family. I've done my best to make educated and very informed decisions regarding savings and investments and whatnot. One of those decisions I will briefly highlight. My decision to roll my wife's 401k into a crypto IRA in early 2018. When I did so, I did it with the knowledge and belief that the currencies I purchased had absolutely no connection in any way, shape, or form to a corporate entity, with accompanying hopes of the value of those currencies increasing based on their utility. Because there was no corporate entity directly attached from which their values were derived, I wasn't buying into the enterprise that is Ripple. I was buying a digital currency that has many use cases worldwide. I dived up her IRA into the currencies that were available at the time, solely based on what I believed to be the future use case of each one. Here were my choices: Bitcoin, Ether, Litecoin, XRP. The last currency, XRP, I chose because I believe in the use case as a currency that could cross borders and be used by anyone, and a vehicle to move value just like gold or US dollar, and had absolutely zero belief that it was dependent on Ripple as a corporation. I knew Ripple had their own processes, products, and markets for those products, but didn't care what they did overall because I knew XRP was a separate entity altogether and was not tied in value to the performance of Ripple. I would not have purchased any of the above digital assets had I thought that they were security of any type. obviously. My own personal IRA takes care of that, holding shares of different companies that I've bought because I believe their positive performance corporately will directly influence and increase the value of those shares. However, my wife's crypto portfolio was a savings vehicle of an entirely different kind, and that is the singular reason why I chose it. I share all of this because, as a tax-paying, hard-working American citizen, I find it extremely frustrating and maddening that the very government entity, the SEC, created to protect us, investors, strongly seems to be the one who is incessantly inflicting damage to the very people they profess to protect. The even more frustrating aspect of it is that it seems there are again and again manipulative and selfishly motivated activities going on behind closed doors, based on both before and after the fact lawsuit inception comments made in various reports and interviews that have come to light during the course of this lawsuit. The decisions and statements made by the various SEC commissioners reek of contradiction and manipulation and seem very intentional to keep clarity and guidance from the investing public for the purpose of benefiting its own desire for control at any cost. In my opinion, the manner in which the SEC is intentionally and comfortably fluid with its avoidance to give straightforward guidance and rules is both dishonest and maddening. I believe any honest and hardworking person who has been following this case would agree. In fact, after careful consideration of all that has come to light in the recent months through this lawsuit, it's become clear to me that the SEC should not actually be the one to rule over this new crypto landscape, but rather the CFTC or some other new regulatory body. Which, by the way, a little side note, I would personally be for that a new body gets formed purely for crypto. They've talked about, kind of making a bundle between the SEC and the CFTC as a task force. I guess that would work too. I know that it is a political issue and not within your power, but what is within your power is to hold the SEC accountable for its deception while it tries to gather even more power. As a person who deals straightforward with other human beings, I've grown weary of watching this case unfold and deeply desire justice and a sweeping change towards honesty, clarity, and institutional integrity on the part of the SEC. I am writing this open letter to you, honorable judges, to plead that you would come to the defense of American citizens like myself by bringing justice to what clearly appears to be a power grab by those behind the scenes who very clearly want to manipulate a market situation that is unclear as of yet. It is my humble opinion that using their power and position, they're taking advantage of this nascent and now currently forming crypto industry to benefit either themselves or some greater entity, which we are not yet aware of. And that's, again, a fun little jab, because a couple of times by now, we have just noticed after the fact that there were a lot of connections between SEC employees and some bigger companies. Those of us who have bought into this space for years know what we have purchased with our hard-earned money, and it makes me sick to constantly see politicians and public officials continually manipulate markets for their own gain. Upon closing, let me say this. I've been a pastor for 20 years, and I have learned the very deep and dark details of the brokenness of the human race. I have learned how to read body language, hear vocal inflections, and to sense overall when things are just not right. When things said do not align with how things are actually. The reason I say this is because, hopefully, my comments will carry a bit more weight. Knowing a bit of my background, I have much experience watching people tell lies to my face. I know the human condition at a deeply intimate level, and it's my opinion that what I have been watching unfold publicly in the SEC v. Ripple case has been a show of human brokenness on the part of the SEC. Please come to our aid with integrity and swift justice by ruling in favor of Ripple and the entire crypto space. Wow. What a beautiful letter. I don't know how else to put it for you guys. What a beautiful letter. Yeah. I don't know exactly if anything will come from this, but at least it's a good gesture that this is being put up. I'm gonna give him a follow for that one. Right. It's him that put it up, right? Let's quickly check it. Here, his name is Brian Chieta. Big shout out to Brian Chieta for this one. That is, wow. I don't know what else to tell you guys. That is, it's really an amazing letter. Right now, let's hope that the judge does something with it. This we already covered in the live stream, and this just came out 2 hours ago. We also covered it in the previous video. If you want to know what this one is about, make sure you check out my previous video, guys. It's online right now as we speak. And I guess that was it, though, right? Once more, guys, make sure you check out Bybit. Make sure you check out my Instagram. A link is down below. And I'll see you guys again in another crypto video later today.